This is great. It's so nice to see your guys' faces. I love it.
Oh, sorry about
That's okay.
But here we go, using my tiny computer.
Awesome. That's so cool. So this is the best part. This is part of the experience of moving into a new digital platform. Pretty soon, in 10 years from now, everything will be so fast. People are like, you guys had problems on the computers? Okay, so to get started, so we're all very excited about this conversation. This one is on, it's called Artist v. Artist. We at Cyberus are very interested in the idea of, okay, well, there's not just the balance between, you know, some other conversations we had today about users being able to take content, but then also what happens when there's artists who are trying to use artist work to create new content, and that kind of creates a new problem. It's no longer the world of consumer v. artist or producer v. artist. All of a sudden, it's artist v. artist. And so, you know, even at Springboard, we have those problems as well. As we, you know, where I work at Springboard for the Arts, right? We have artists who want to, you know, use a popular work to create a new work, and then we have artists who want to stop other people from using their works to keep the competitive advantage up. And so to get started, just to kind of give us a background into this discussion, I'm going to have Niels Schauman start us off, and I'm going to do a quick introduction of everybody. Okay. So Niels Schauman is the president and dean of California Western. Before that, he was a professor for faculty at William Mitchell College of Law, which is where we are at for Cyberus. He is an expert in copyright law and federal security regulation, and has taught courses in copyright law, computer law, comparative and international intellectual property. He's a frequent speaker on topics of copyright law and securities law, and has often served as an expert witness in copyright. And then I'm going to introduce Amanda Schreyer. Amanda Schreyer's practice at Prince Lobel consists of representing new media entrepreneurs, bloggers, interactive software developers, and publishers, and writers and filmmakers. And she graduated from Boston University and received her JD. And then when she was in law school, she was the executive editor on our law review, so she's one of our people. She has been a guest lecturer at Northeastern University School of Law and Suffolk University Law School, where she was also a legal practice skills teaching fellow. She's a frequent speaker on legal issues and blogging at conferences across the country. So great pair to have together. So to get started, Niels, do you mind telling us, you know, can you explain just basically what the fair use doctrine is?
Sure. Fair use is in the 1976 copyright is essentially the only broadly applicable exception to the rights that copyright grants to authors. So the way the Copyright Act divides things up, and this is very intentional, authors have the right to do essentially anything with the work. The definitions and the language that assigns them rights is extremely broad. The exceptions to copyright are very, very narrow and mostly applicable only to one group of users or another group of users, for example, terrestrial broadcasters or libraries. And the only one that is of general application to anybody, depending only on the nature of the use rather than the nature of the user, is fair use. And fair use was originally a case-based doctrine that says that under certain circumstances, certain kinds of uses are socially useful and valuable. And so, notwithstanding the rights of the author, these uses should be allowed. And that was codified in 1976 in the 1976 Act. And ever since, fair use has been about courts interpreting that language, and sometimes even going back to the earlier cases.
And then how would you say, so one of the goals of fair use, how do you feel the courts accomplish the general goals of fair use doctrine?
Well, you know, that raises the question as to what the goal is of fair use, right? And that, depending on who you talk to, you might get a different answer from any given set of people. I think that, you know, the way I've looked at fair use for a long time is that copyright itself has two principal purposes. One of them is to increase public access to works of authorship, and that's really the fundamental purpose, to promote the progress of science, essentially. That's the language in the Constitution. But the other purpose, which follows in the next paragraph, or I'm sorry, the very next line, it grants to authors exclusive rights. So it also has a purpose of remunerating authors and making sure that they can earn a living by creating the works that the public will have access to once the copyright expires. And so fair use is kind of the crucible in which those two purposes of copyright are weighed against each other, and we decide whether or not the public's interest should trump that of the author in being remunerated in any given case.
All right, and so now, Amanda, we're going to flip back to you a little bit. Can you give us a general overview of, you create content, you're a content creator, and what are the sort of the rights given to you as that owner?
Well, you have the certain exclusive rights as enumerated in the Copyright Act, the right to generally to control the dissemination of your work, the copying, the publication, the creation of derivative works, and we do have in the United States a limited moral right that authors can control what is done with their work in cases of fine art, which I'm sure Dean Schauman is better versed than I. So essentially for a certain period of time, which has been extended and become a long, long period of time, if someone wants to use your creative work, they need permission from you to do so unless that use falls under fair use.
Wonderful. And then, okay, so then the most famous artists for using other people's works are appropriation artists. So can you explain, Niels, what that is?
Sure, and I should point out that, this debate about reusing other people's creations is actually not a new thing. It's just that most recently it's playing out in this realm of appropriation art. But Mark Twain, for example, as a young man, was all in favor of weak copyright. And then the older he became and the more valuable copyrights he accumulated, he began to favor stronger and stronger copyright to the point of actually going to Congress and lobbying them for better and less porous copyright. But appropriation art is a genre of art that, in the article I trace it back almost 100 years, but under that name, it's really been around since the 1980s. And the most flagrant cases which have resulted in litigation involve more or less wholesale copying of somebody else's art, but recontextualizing it so that an everyday object suddenly appears in a gallery. Or somebody uses an illustration from popular culture, not necessarily a work of fine art, in order to make a point about banality in American culture. And these kinds of things have generated a lot of litigation because on their face, somebody is using somebody else's work. That seems very clear, and the issue is it fair use or not?
And should, we as consumers, people, citizens, take this appropriation art seriously, and should judges?
Well, that's a great question. I think they should. But the problem is essentially this: if judges don't take it seriously or don't treat it as art, then in effect what they're doing is appointing themselves as the arbiters of what is art and what isn't. That is a very sensitive question. It's been asked for hundreds of years. Generally, when the government gets involved in making determinations about that, it leads to censorship, repression, and all kinds of ugly things. There are lots of instances in history where that has happened. And I believe it was Holmes who made the statement that, that is one thing federal judges should not do, is appoint themselves as arbiters of what art is. And yet, when you read some of the Second Circuit cases from the 1980s, it clearly seems that that is what they're doing. And I think that's dangerous. So we should take it seriously.
And, what are your thoughts on the fact that a lot of this has been sort of judge-made law, and that Congress hasn't responded to the conflicts with fair use?
Yeah, that's a really good question. There is one overriding reason why that doesn't happen, and it is that the way copyright law is made is by industry-wide consensus. And in this case, when I say industry-wide, I mean all the copyright industries. Congress can't really act without the consensus of all of the copyright industries, and that is a problem because everything requires a quid pro quo. And so it would be difficult for them to just unilaterally say, okay, well, we're going to amend the fair use statute. It has happened. I mean, they have added some relatively harmless language to it in the past. But it's very difficult for them to do this, and anything that allocates substantive rights or reallocates those rights is very, very sensitive. So copyright's essentially been written by the entertainment industry for copyright law for the last 100-odd years.
So that sort of brings me over to Amanda. So Amanda, from your perspective or your opinion, how do you feel that the law currently balances the exclusive rights of a copyright owner with the public domain?
I think that we can talk about how, let's see how I want to address this. Well, currently, first of all, I agree with Dean Schauman that the entities with the deepest pockets are the ones who make the statutes. They are the ones who get statutes made and changed. And it is up to the courts then, for better or worse, to decide when the facts at bar fit into what the statute has said. I don't think that that's going to change in the near future. I know that copyright law is going under complete review and could be seeing a number of substantial revisions. I don't know if fair use will be one. Right now, I think my point of view is more from, or I'd like to take this question from a commercial standpoint. I think that fair use and copyright law in a commercial context is different from copyright and fair use in an artistic context. The problem is who decides what's commercial and what's artistic. From what I'm talking about, if we're talking about protection of characters, a character that was created 100 years, 80 years ago, right now probably we're focusing more on the commercial aspects of that creative work rather than the artistic aspects of that creative work. So right now the way we have it balanced is that the owner, who I will point out is probably not the creator of the work, the original artist at this point in the context in which I'm discussing, in order to be incentivized to create new entertainment products, for example, to create new works, they need to know that they're not going to, they're going to be able to control those works for a certain period of time in order to get their money back, quite frankly, and to be able to exploit the properties that they have purchased. The way that's balanced is by the public domain, that works do go into the public domain after a certain period of time. Now, an argument for, I don't know if it will be this panel or perhaps another day, is whether that amount of time is far too long than what was originally intended in the constitutional clause. And so we've got, so to more briefly answer your question, the balance is exclusive rights allow ensure that the public gets a high quality product and they get more of that entertainment product, knowing that at some point in time that work is going to go into the public domain for everyone to enjoy. Now, I would submit that everyone gets to enjoy the work while it's under exclusive rights, but there's a new market for that work once it's entered the public domain, which anyone that enjoys that character or other work is able to incorporate it into their own work. Now, something that I find interesting between works of art, capital W, capital A, and of course these types of products that we're talking about, is that a character, for example, is also going to have other protections around it once copyright is expired. There's probably going to be trademark rights. There may be rights of publicity, whereas my understanding of
Amanda?
longer. Yes.
Oh, sorry. You just the video froze for a second, but you're back on.
Oh. Okay. Where did you lose me?
I think the last thing I heard you say was my understanding. and then it kind of went dead over here.
Okay, well, we'll just move on from there because it's not important. I'll add that to another answer.
So Dean Chapman, I guess could you summarize, just because I know that Amanda has some questions for you as well,
Sure.
what exactly your proposal is?
Yeah, and by the way, Amanda, I want to point out that you probably know this, but one of the things that Jeff Koons did in the 1980s was borrow Odie from Garfield and put Odie into a sculpture. And for that, he was sued by, I can't remember who it was, King Feature Syndicate or the entity that controlled that character. And so, I think my proposal...
Oh, yeah, I would...
Go ahead.
I was just going to say, I was hoping we could talk about Odie. I thought that was a really good example of how these worlds meet, so we'll save that for later on. Please continue.
Sure. So my proposal essentially is that when an artist creates a work of visual art, as the way that's defined in the Act, which is essentially painting or sculpture that exists in editions of 200 or fewer. There's a lot of other language in the Act about things that it can't be. It can't be a commercial photograph, an advertising photograph, a map, a globe, and so on and so forth. But essentially, if it's gallery art existing in an edition of 200 or fewer, then that qualifies as a work of visual art. And this ties back to something Amanda was saying earlier, because those kinds of works are also protected by moral rights. They're the only works in the United States that are protected by moral rights. And I think a work that meets that definition, almost by definition, can do no or very little harm to the commercial value of the work that it copies. For example, Odie. It would be very difficult to bring a case claiming actual damages from Jeff Koons' use of Odie. It's done more for purposes of censorship and to control the character, to make sure everybody knows you can't do this without asking us first. But in fact, I think there's very little actual harm done, and I think the cost that we as a society bear by stopping those kinds of uses is really far too high compared to the rather tenuous benefit that the plaintiff gets from it. There are First Amendment aspects to this too, but I mean, I think just from a copyright point of view, the cost of this seems to be way too high. I can't see any good economic reason, and American copyright is nothing if not economically based, why we should prohibit uses like that. And the language of the courts is pretty moralistic. It's, well, it's wrong because it's stealing, but that's sort of bootstrapping. It's like saying it's wrong because it's wrong. There isn't a lot of reasoning as to why that is the case. So in a nutshell, that's my proposal. As long as the offending work is one that was created and meets the definition of work of visual art, I actually think people who create those kinds of works should be given a free pass.
And so,
oh, sorry.
Oh, that's okay. Amanda just had a response to this on why she thinks this might upset sort of the balance between exclusive rights and public use.
Yeah, I wanted to clarify, is the proposal that all works of art, any appropriation art that qualifies as a work of art under the Act, is really exempt from copyright law? Or that there should be a presumption of fair use, almost like a fifth factor to be determined in a fair use analysis?
Well, I actually, that's a really good question, but I actually don't favor the addition of a factor to fair use. And the reason for that is that fair use, to establish fair use on the merits, requires litigating a copyright case through the merits, generally. It's an affirmative defense. Sometimes courts will put that first, but usually they don't. So the cost to an individual of establishing their fair use right under the statute's about, I don't have current data, but the American Intellectual Property Lawyers Association, or APLA, actually does a survey each year of the various kinds of litigation and what that generates, in fees. And it costs about $300,000 to litigate a case on the merits in copyright law back in the 90s. It's got to be a lot more now. So rather than make people go through that, I would just say it's not just a presumption, it's a qualified privilege. I just can't think of any way that you would be doing any kind of damage to a character's economic prospects or to any other kind of an artist's economic prospects by using the work that way.
So what are your thoughts on that, Amanda? Do you feel like that proposal, like there are economic harms in allowing for this?
Well, one concern I have is a practical one of is it a slippery slope to be carving out one type of art that is defined by Congress, and they get exemption from the copyright laws? That seems to be the biggest leap to make here. Yeah. Will some other group say, hey, what about our group? We shouldn't have to deal with these 95 plus years of exclusive rights either. And that would is that maybe going to be the instigator to the erosion of the copyright laws as a whole? I'm kind of doomsday here, but I think that to go back to one of your first comments is I completely agree that it's unfairly expensive for people to have to litigate over whether something is fair use or not. Also, the fact that it's judges who are making these decisions is kind of frightening. I know nothing about art. I don't think that most judges are qualified to be determining what is art and what isn't. So the meta question is, how do we fit something? It's very easy to talk about copyright in the context of a book. We all know what a book is. Even a video game, we all know what a video game is. But what makes something art? And when we give art a special category under copyright law, that's the part that that's pretty frightening to the established regime. For how would copyright owners react? You know, I feel like, let me give you an example like this. If you are the struggling, starving artist, I'm not even going to take the position of the mega corporation, you know, Marvel, Disney. I won't even go there. But the artist who has been struggling all her life to gain some notoriety, i.e. money, for her art, and finally gets a licensing deal for that work, should someone be allowed to take her work and make it into their own repercussions whatsoever? I think that there could be market harm. I mean, if I were, and I'm sure this is what the Odie people argued, was that there is a market for giant Odie sculptures, and if we wanted there to be giant Odie sculptures sold, we would do it because we have the exclusive rights to do that, and you shouldn't be making millions of dollars off of a property that we own.
I'm sure that you're exactly right, that they feel that way. But you know, one of the points I make in the article is that the fine art market is very finely divided, and people there know what they're buying. They know the difference between an original and a reproduction, for example, and they know the difference between a Jeff Koons and a Richard Prince and a Jeff Koons or a King Feature Syndicate item. And so it's really a question of, if they want to pay for the Jeff Koons, it's because it's by Jeff Koons. It's not because it's Odie specifically. And so I would say, but I would say a lot of the points that you raised are very important. I agree that we should not have an exemption for any particular kind of art. I think we shouldn't, for example, say this is limited to appropriation art. That term has no legal meaning. I think we should just say if it qualifies as a work of visual art, which is an accepted definition that's already in there, then not only are there moral rights in it, but it is exempt from enforcement of the economic rights of a copyright holder. Because I understand that King Features believes that their Odie is probably just as valuable as Jeff Koons' Odie, but I think that the world of art collecting probably strenuously disagrees with that. And it would be, again, difficult or impossible for them to show that their position I'm sure they do make three-dimensional OD reproductions, that those were harmed by the existence of these 5, large, very, very expensive sculptures that are, on display in museums and in the homes of a few wealthy collectors. It's just hard to make that leap. I understand that copyright law, traditionally says that that's not allowed, and that's what the Second Circuit said. But from an economic basis, I just don't see why that has to be the case.
Okay, so one thing that we can kind of move into talking about is outside of the idea of, it's still within artist v. artist, but something that's very topical right now and popular discussion amongst copyright scholars is the question of how much weight do we give the transformativeness factor in fair use analysis. And so first, Dean Schauman, do you mind giving a really brief overview of some of the factors for deciding whether something is fair use or not?
Not at all. So the first factor is the nature of the use. And what that, the nature of, somebody's accused of infringement for copying. The question is, in what context did that copying take place? Was it for classroom use? Was it to sell products? What exactly happened here? And Congress specified 2 things that should be considered here, whether it is for educational or nonprofit educational uses on the one hand, or for commercial uses on the other. And so for a long time, the courts interpreted that pretty strictly, and if it was a commercial use, it was going to be very difficult to find that it was fair use. And that changed a little bit later, but I think it's safe to say that commercial uses still struggle a lot more than nonprofit uses do. The second factor is the nature of the work that's being copied. So here, if it's a history textbook, for example, a copier is going to get a lot more slack because the facts of history are nobody's property. And so you have to use something as a research source. So copyright is a little bit weaker there, whereas if it's a work of fantasy, there's theoretically no social need to reproduce that, and it should be reserved for the original author. The third factor is how much of the work is copied, and that has an interesting history too, but obviously if the more you copy, the less likely fair use is. And finally is the impact on the market, which at various times the court, and this is the market for the work that was copied from, and at times the Supreme Court has said that this is the single most important factor. I think it should be the single most important factor because, in fact, most of American authors' rights is based on economic principles. Amanda referred to them earlier, the incentive that authors need in order to be able to create their work, to control it for a period of time, all of that. So if something is really destroying somebody's market, it's very difficult to say, well, that's fair use, particularly if it's substituting for the author's original work in the marketplace. So those are the things that courts look at.
And so, Amanda, can you talk a little bit about your thoughts on how recently, especially in the Richard Prince decision, we saw the courts really put a lot of emphasis on the transformativeness of the new work? And what are your thoughts on that? Are we giving it too much weight?
I like giving transformativeness more weight than harm, because maybe I'm just a softie and not looking at only the economic incentives of creating creative works, but more of a fundamental fairness of what should be allowed. To me, the more transformative a use is, the more it takes it away from the original work and more towards the second comer's creative work. You have built off of an existing work without wholeheartedly usurping the market for it, and you have had to put some level of your own, some quantum of your own creativity into it in order to be found not to have infringed it. I put less weight on, it doesn't matter what I think, but I I appreciate the courts putting more weight on transformativeness than the other three at the moment, which is the trend. For that reason, because it's so, and I think probably it's because it's so easy to get other, or one factor is that it's so easy to get other people's work, and it's not that we reward sweat of the brow for copyright, but I feel that if you are going to be using someone else's creative work, that you got to at least put a little bit of effort into making it something else that's your own in order to claim your own rights in it, whether they're economic or not.
Okay, and then, you know, what is the difference to you two about the difference between, you know, taking, you know, in the situation of Richard Prince, taking photographs from somebody else and putting them into a painting versus using, say, a fictional character to create your own plot line, storyline, book, novel, using an existing character versus taking an image perhaps and translating it into a new work?
Oh, well, that's a really interesting question. I think, you know, first, images generally have been much more strongly protected under copyright law than characters have per se. Characters are only protected if they're sufficiently delineated, and the law there has tended to favor comic book characters over literary characters because they are drawn. So at the image part of the character, like Mickey Mouse, for example, or Odie, becomes very easily recognizable, and so cartoon characters have had the easiest time of it. Images, on the other hand, have been pretty strictly protected all along, and they're usually viewed as being at the heart of what copyright is all about.
Do you have any comments on that, Amanda?
I lost you a little bit, but I think I got the gist of what you were saying. I think there is a difference, that there is a difference between taking a character. Let's talk about a visual character. Okay, let's talk about a comic book character, and I think it would be hard to say that you're not infringing on the market of the copyright owner if you take a character and you put it into your own work, a new plot line, new stories, interaction with other characters. I think that certainly would infringe on the market for the copyright owner, more so than just making a giant, really expensive sculpture of one of the characters that only exist in museums. I think it's a different analysis. I don't know if there should be, but certainly the commercial aspects of that situation of reusing a character certainly affects the market for the use of the character owner. You know, that's the kind of thing that they hire artists to do, and that's how they continue to exploit their characters, is through coming up with new scenes and new plot lines and new movies and new video games, and that's how they maintain not only the return on their investment, which of course is diminishing over time, but or the need to recoup that investment diminishes over time, but also the quality of the character. They're able to control what sort of situations the character might be in, and it also ensures that the consuming public is getting a certain level of what they expect from that character. You know, there's a reason why George Lucas doesn't. You're not allowed to go make your own Star Wars films, for example, even though he does appreciate at some level the fan works, and there is a space for fan works, which it seems to be was your initial question, but not to the extent of infringing on the market.
Well, it's interesting to me because fictional characters seem to benefit the most from the extremely long-term limits of copyrights now, right? A book or a painting, it's sort of if you like look at the charts, right, there's sort of this, oh, okay, losing value, and then once it gets to public domain, it goes back up, right, because all of a sudden you can, make 100 copies of Little Women or whatever it is. But then, with fictional characters, it's like, okay, well, this character is going to be remade into new movies and re-envisioned, and it becomes almost a part of our American culture.
Yeah, it does very much.
Yeah.
So then back to sort of making money off of art is, there are artists out there who don't want to make money, but I feel like I can speak from professional experience in saying that a lot of artists do want to make money, including appropriation artists. And so what does that have to do with the analysis of fair use? In the case of Richard Prince, he was a much more famous artist than the original photographer. The photographer made a book that I think he made about $3,000 off of. Richard Prince was able to take those pictures and put them into paintings and sell them to celebrities for a lot of money. And so what are your thoughts on just sort of like the fairness of sort of the rich artist versus the poor artist, and the ability to grab something that a poor artist couldn't market very well and throw it into a new work and then use their fame to market it even more?
You put your finger on one of the things that really bothers people frequently in the appropriation art cases. It does often tend to be the poor artist versus the rich artist. But, the problem is really with the art market. It's not the artist's fault. The rich artist, the reason collectors will pay so much for Richard Prince's work is not because of the images it contains, but because of the signature on it. Anybody who doesn't believe that that's the case is kidding themselves. It's very important as to who created that, a given work of art. That's what drives the price. So, as hard as that is to accept for the photographer, for Patrick Carrier, there is simply no way that he could have created Richard Prince's work and sold it for millions of dollars. It's not as though Prince was appropriating something from Carrier. He's Prince, and that's why he can make a lot of money off it. Interestingly enough, the same sometimes happens in other copyright areas as well.
Mm-hmm.
In the music business, it's frequently recognized that, one record might sell because of who it's by. If it was an unknown that had recorded that, it probably would not sell. So, these are the facts of life in the 21st century. I understand the resentment that engenders, though, but I don't think that should be determinative of the legal outcome.
I don't think it would necessarily needs to be determinative, but to me, what you're saying, it makes it seem more important that we have a fair use analysis in a situation like this. I just have a problem with it being okay for the rich guy to just take the work of the not rich guy, even though it's okay even though he's going to say in the way it was, he would say it's fair use, and I'm going to get the best lawyers, and they're going to make sure that they argue that, and I win on fair use. In your regime, it would be a not even issue. We wouldn't even be arguing about it. That to me just seems unfair. I don't know what role there is in this discussion or in copyright law for that kind of fairness. Maybe there's some other. I don't think it's the kind of thing. Some other restitution almost for Carew. Is it financial? Probably not. That's why I think when I hear what you're saying makes me think that there should be more of a reason for a fair use analysis and not less.
Well, this is definitely an issue on which two reasonable people can disagree.
No, it's really difficult.
In my mind, though, there is the concern I have is that, I think there's a reason why it's rich artists that are doing it right now, because rich artists are the only ones who can afford to be sued. I think that, there are a lot of struggling artists whose artistic vision would include something like this, but they're constantly advised to stay away from it because of the threat of litigation. Mm-hmm. And those are the people who could be creating things that we will now never see because they can't afford to spend $300,000 on a fair use defense. I think art does occupy some kind of a privileged position, and I would argue that if it fits that definition of a work of visual art, then regardless of the commercial interest at stake, and because works of visual art don't really dent the commercial market, that it should get a free pass. I just don't see the harm that's done, although I do, as I said before, it seems unfair, it upsets people, probably for those reasons alone. It's not something that Congress will ever do, but I think a court could do that. A court could recognize that in the appropriate case, and I hope they do.
I mean, this question is always brought up for every art form, but, would you be favorable to some type of compulsory system?
Yeah, I guess. I mean, it's better than what we have now. It would certainly be cheaper. It would be pretty controversial. I mean, I don't know how you set a value for licensing on those kinds of things. It'd be tough.
What if it was a percentage?
We can't even get it right yet for music.
Yeah. True.
Well, you should listen to the students from the Google Hangout before this. They had a lot of really good points to say on that.
Yeah.
So that being said, I think we said a lot of amazing things today. Does anybody have any final comments?
I do. I just wanted to add on perhaps a good regardless of our positions on whether fine artists should get a pass or not, I think it's clear, and it would be nice if there were more discussion about this, that the problem is how much it costs to assert your rights. I completely agree with you, Dean. It is an affirmative defense. You only get out of jail grand after you have gone to court and defended yourself.
Right.
So let me just, so maybe if part of the conversation of how are we going to amend how should the copyright law be changed, this is probably a question that all legal practitioners have, is that we're making it unfair because the people who need the access to the judges, if only judges are going to be able to decide this, we need to make it easier for everyone to have access to the judges.
Mm-hmm. I agree. There is a problem with the cost of litigation. I have no solutions for that. That would be a really law review article.
Yeah.
But,
well, the U.S. Copyright Office has a lovely report on the small claims court, at least.
Yeah.
Yeah, that's true, and maybe that's a step in the right direction. That's a good point, Sarah.
Yep.
All right. Do you have any closing remarks, Dean Schauman?
I would just say, I mean, this discussion, I found it fascinating. Thanks very much, Amanda, for participating, and thank you for setting it up. Sarah, I would just say that the subject matter that we've ranged over today really illustrates why I love this field so much. I mean, copyright, it deals with multi-billion-dollar commercial properties, and also the most also works of fine art. I mean, there are very few fields that really will address both of those things, and in many ways it gets right to the heart of what those creations are, and that's one of the reasons why I really like it so much. So it's been fun.
Me too. You just spoke to what I feel too. I'm smiling. I'm sure Amanda can feel the same way.
I agree entirely.
Yeah.
I agree entirely. I usually have to bore friends and relatives about my thoughts about copyright and intellectual property law, so I appreciate it when I actually get asked to do it.
Yeah, good point. I don't dare do that any longer.
but it's true. There's so much. Not only is it such a broad range, but every day there are new technologies being introduced that just change it every day. So I think despite how the problems with all of it, it is a pretty fascinating field to be in.
Absolutely. We didn't even talk about Aereo. There's a
there you go.
technology case. So.
Well, someone could write a law.
Yeah, that's going to have to be the next issue.
Definitely.
Someone could write a law review article about the legal rights of this Google Hangout.
Yeah.
So there you go. Well, anyway, thank you guys so much, and have a wonderful weekend, and thank you for participating in our event.
Thank you, Sarah.
Thank you very much.
Thank you, Dean Schauman. Thank you,
Sarah. Thank you, Amanda. Thank you,
Take
Sarah.
care.
Bye-bye.
Yep, bye-bye.